members take their seats. If the IT person could give me who's on WebEx.
Gordon Mahallahan, Matt Sterling, and Michelle Segan.
Thank you. Members that are on WebEx of the committee? None? No members? Thank you. First up, was everybody sitting around last night not watching basketball, but actually reading amendments? That's what I was doing. And I did turn one of the games on for a little bit. But, it wasn't a very good game. Maryland lost, I believe. So. But anyways, I got a distinguished phone call or email last night from one of our representatives who he requested a bill introduction today. He is a member of the House, so he can introduce a bill. I would recognize for bill introductions the distinguished representative from Sedgwick County, Carmichael.
Thank you, and good morning, Mr. Chairman. Always a pleasure to have any excuse to appear in front of your committee. My name is John Carmichael. I'm the state representative from the 92nd District, and I'm here to request the committee's introduction of 2021 RS 1842, the short title of which is a proposition to amend Section 22 of Article 2 of the Constitution of the State of Kansas relating to legislative immunity from arrest and civil service of process.
Thank you. Just for my edification, how many pages is your bill?
How many pages?
Yeah.
Well, Your Honor, as a matter of fact, the entire draft is 1.5 pages, so I'm sure the committee will have plenty of time to hear this legislation promptly.
I'm sure. Without objection. Matt, do you have the number?
I do, Mr. Chairman.
Thank you. Without objection, we will accept your humble bill.
Thank you for your courtesy, Mr. Chairman. Have a pleasant morning.
Thank you. I think you're going to, what are you going, Commerce or?
Utilities, well, where we will be accomplishing nothing this morning.
Good. Just keep the lights on for us, would you? Thank you. We are back on House Bill 2184. We had several amendments offered yesterday. What I'm going to propose is that we take all the amendments in that have, and then we can go to the question and answer period of those amendments. I understand there's probably, would it be reasonable to think there's 10 additional amendments? Representative Carpenter, you indicated.
Thank you, Mr. Chairman. I do have a second amendment package.
Okay. I'm going to go around to the rest of the committee first.
Yes, sir.
For those members that have not entered an amendment, please identify yourself. Raise your hand. Representative Hoyt.
Thank you, Mr. Chair. You want me to go ahead with this one now?
Do you have the copies of
I do. I have copies right here if you'd be willing to distribute. This one's a short one. It addresses child-resistant packaging. Currently, there is some language in the bill on page 19 for when it goes from the processor to the distributor. This amendment addresses when it goes from the dispensary to the consumer and would require child-resistant packaging.
Thank you, Matt. You have a quick explanation for the amendment?
Thank you, Mr. Chairman. Representative Hoyt described it correctly on page 19 of the bill pertaining to processors. There are requirements for packaging to be in accordance with child resistance effectiveness standards required under federal law, and this would take these same requirements and apply them to dispensaries.
Thank you. Any questions on the amendment? Yes, Representative Carpenter.
Thank you, Mr. Chairman. I'm not familiar with that section of the law. Is this just saying, like, if somebody were to get like a pill capsule bottle, it has to have something like what you'd see on a Tylenol bottle? Is that basically what this is doing, or is there more to it? Thank you, Mr. Chair.
I'll direct that to Matt.
If the committee will give me just a moment, I'll pull up the CFR so I can answer that question more fully.
Take your time.
So thank you, Mr. Chairman. So the reference that would be put in would be to 16 CFR 1700.15B, which pertains to poison prevention packaging standards. It details effectiveness specifications, which require special packaging that meets child-resistant effectiveness of at least 85%. Without a demonstration, and not less than 80% after a demonstration of the proper means of opening such special packaging. It pertains to ease of adult opening. There's basically a detail of specific standards for the basically the ability to open a package, and that applies to other prescription drugs, and it would be applying this to the package that was dispensed by the dispensary.
Thank you, Representative, with that clarification for you. Thank you. Other amendments, Representative Smith?
Thank you, Mr. Chair. Yeah, well.
She has them.
That's right. Okay. I think the first one will be, it shows a page number at the top of 28. Sorry, 22. Page number 22 should be the first page. I don't know, flip it over and see if it says 22. Not that one, the other one. That should be it. I may have them out of order. Basically, what this amendment does, Mr. Chairman, if you want me to go ahead.
Please, go right ahead.
So what I'm going to do is I'm going to see Representative Hoy's packaging and raise her a tamper-proof specific, Kansas-specific seal on the packaging. In other words, at the top will be something that if you break the seal, you'll be able to notice that it's been opened. What I would call this is an open container law for THC marijuana. Basically, it further restricts that if it's being transported by a motor vehicle, it must be in that original packaging unbroken, the seal unbroken. And that if it is broken, then it has to be kept just like whiskey or alcohol in a locked trunk or area away from the driver and occupants inside the vehicle. And there are a couple of little exceptions in there for that, just like there are for alcohol. But it would be treated in the same manner. I suggest this as based upon my experience with what we see out there on the road as far as the use and abuse of marijuana and when it's readily accessible to the individuals inside the vehicle. Probably driving down the road is when you want to restrict when it's being used by anyone like you would alcohol. So that's the basic premise of it.
I'm going to go to Matt now. Matt?
Thank you, Mr. Chairman. So yes, the representative's amendment does basically three things. That one, when dispensing medical marijuana, it requires a dispensary to dispense it in that official tamper-proof Kansas-specific packaging that he described. The next change on page 25 would be to require the director of ABC and therefore the Secretary of Revenue to adopt rules and regs to establish official packaging requirements that make those, that designate that Kansas medical marijuana and ensure that the packaging is tamper-proof. And then the third piece was that new section 48, which is modeled off of the existing law for transportation of alcohol in a vehicle, and prohibits the transportation unless it meets those exceptions that are the same as what exists currently for the transportation of alcohol.
Thank you. Questions of the reviser or the maker of the amendment? Seeing none, would you like to offer your second amendment? Would you put your microphone on or move it up?
Got to turn it off. High potency THC, a restriction against high potency THC. Basically, it sets a cap at the level of THC for any medical marijuana at 15%. For those of you who aren't in the industry or don't have a firsthand knowledge of how that works, back in the 80s and 90s, your normal marijuana would be somewhere under 5%. Currently, street potency is somewhere closer to 15%. You do run into higher potency for specific strains and specific, I guess, mixtures and compounds that they come up with for edibles and such out in Colorado. This would set that in Kansas. We don't need anything over 15% THC, and anything at that level or above would be a violation. I'll let Matt go over the levels of violation.
Thank you. Matt?
Mr. Chair, we haven't gotten the correct amendment.
Yeah, there's a second amendment coming out. It's another page.
Second amendment he's handing out now. Matt,
Yes.
could you explain the second Smith amendment?
Thank you, Mr. Chairman. And the correct amendment that Representative Smith is describing should, with the header, should say possession of THC on it, just to make sure everybody has the correct amendment. It would, as the representative indicated, it would make it a Class A non-person misdemeanor for a person that was found with possession of marijuana, medical marijuana with a THC content that is over 15% but less than 25. And it would make it a level 5 felony for a person to be in possession of marijuana with a THC content that was above 25%.
Thank you. Questions of the maker of the amendment? Seeing none. Representative Woodard, do you have an amendment?
Yes, Mr. Chair. I have two, and they're being printed and brought up. If you'd like, I can offer them, explain them, and then deliver copies once they're brought upstairs. They're both pretty simple.
Let me see if they have others that have their copies, and we'll wait for your copies to come up. Representative Howe, do you have an amendment?
I do. Connie they have copies they can distribute.
While they're distributing, would you explain your amendment?
Thank you, Mr. Chairman. My proposed amendment would only allow licensed physicians to prescribe medical marijuana or medical cannabis, and the prescription would have to be dispensed by a licensed pharmacist and a licensed pharmacy.
Thank you. I'm going to have Matt further explain. Matt?
Thank you,
This
Mr.
would be-
Chairman.
You have two amendments? One amendment. Okay, this will be Howe amendment. Okay, thank you. Go ahead, Matt.
Thank you, Mr. Chairman. So the amendment does several things. One, basically every reference in the bill that is to a physician recommending medical marijuana for treatment, it will be changed to require a prescription from a physician. It would change the definition of a retail dispensary to mean a licensed pharmacy that was operated by a person who was a pharmacist licensed in the state and who had registered with the Board of Pharmacy and been issued a license by the director of ABC as a retail dispensary. And then if you go to section 31, requires the dispensary to be a pharmacist that was licensed in the state and registered with the Board of Pharmacy in accordance with rules and regs adopted by the board. And then would, on page 26 of the amendment, would add a new section 40, requiring the Board of Pharmacy to adopt rules and regulations that would establish the requirements for a pharmacy to register as a retail dispensary and to report all transactions of a retail dispensary to KTRAX. So the essential policy changes of the amendment would be to require a prescription from a physician as opposed to a recommendation, and to require that only a pharmacy operated by a pharmacist would dispense medical marijuana.
Thank you, Matt. Questions of Matt? Yes, Representative Reese. Heiberger, I'll come to you.
Thank you, Mr. Chairman. So, Matt, this would make this be a controlled substance subject to being licensed by the DEA to dispense?
I'm not sure. I'm not sure. Can you please repeat your question? I'm not sure I understand it.
Would this reclassify this medical marijuana as a controlled substance?
So it would not reclass. I mean, medical marijuana or marijuana is a controlled substance under the Controlled Substances Act. It's a Schedule I controlled substance. So that's federal law. That cannot be changed. What this amendment would be doing would be requiring that medical marijuana in Kansas be dispensed by a pharmacy after the receipt of a prescription from a physician.
Thank you. Representative Heiberger, you had a question?
Yes,
Is it to
thank you.
Matt? Or
Yeah, for Matt.
Okay, thank you.
A couple of questions. They're both short, though. Would this bill as amended actually authorize pharmacies to store and distribute marijuana or THC or cannabis? And two, do the parts of this amendment that affect pharmacies conflict with any federal law?
I'm sorry, Representative. I lost part of your question there. Could you please repeat it?
Did you get that, Matt?
I did not. I'm sorry. Could you please repeat your question, Representative?
A couple questions. One, would this bill as amended actually authorize pharmacies in Kansas to dispense marijuana? And two, do the provisions relating to pharmacies conflict with any federal statute or regulation that you know of, other than the federal prohibition against possession of marijuana?
Thank you, Mr. Chairman. So the amendment would require that if medical marijuana was to be dispensed in Kansas, it would have to be done by a pharmacy. As for conflicting with federal law, marijuana is a Schedule I controlled substance. Pharmacies are licensed by the DEA. Currently, since I believe it's 2014, Congress essentially passes a budget proviso every year, or at least they have since 2014, that prohibits the Department of Justice from expending any resources to enforce violations of the Controlled Substance Act for medical marijuana in states that have legalized medical marijuana. So to your question, it does conflict with what's in the Controlled Substances Act. Congress has since 2014 passed budget provisos saying that the DOJ can't spend any money to enforce that conflict. So different states I think, have approached this in different ways. I believe a couple states have authorized the dispensation of medical marijuana through pharmacies. Others do it through dispensaries.
Thank you. Thank you. I have a question for the maker of the amendment. You're assigning this responsibility to the Board of Pharmacy. Have you spoken with them on, are they amenable to this?
Mr. Chairman, I have not spoken to the Board of Pharmacy about my specific amendment, nor have I spoke to any lobbyist representing the pharmacies or pharmacists. This is just an idea I had. It's probably a little bit more of a conservative approach, but I feel like we're walking in kind of the Wild West, if you will. We're absent the federal government stepping in to enforce any current laws under the Controlled Substance Act and letting states kind of go willy-nilly and do what they want. I feel we need to take a conservative approach, and this would allow us to do that.
Thank you. Representative Epley. No questions? Okay. Then we have that amendment. I've marked it as the Howell Amendment number 1. Other amendments. Someone behind me? Yes, Representative. Do you have your copies?
Yes, sir, I do.
Does Connie have them? Okay. Jeannie? They're right here. And I will mark this, the Penn Amendment 1. Representative Penn. May I explain your amendment as it's being handed out?
Thank you, Mr. Chairman. I appreciate it. Matt, if you could bring it up on the screen, please. This is a quick amendment, sir. Basically on the bottom of page 13, where we talk about the 90-day supply, how you're allowed to carry an amount not to exceed the amount for a 90-day supply. It was a little vague and unclear. I think we need to put some parameters around that. So I just basically have this amendment inserting that language as we see above, as specified in the rules and regulations adopted by the Secretary of KDHE. The second part of the amendment on the second page, sir, Mr. Chair, explains how we insert a new section 20 to make this into a 3-tier system, kind of on the model that we see in our alcoholic beverage, so that there's not a conflict of interest in those holding the licenses for what we're proposing. With that, I would like to return it back over to you or have Matt explain.
Thank you. Matt, would you care to explain?
Thank you, Mr. Chairman. As Representative Penn indicated, the first change just specified that 90-day supply would be specified in rules and regs adopted by the Secretary of KDHE. The second proposed change would require that would prohibit that a license be issued to any licensee, to any existing licensee, if they had a beneficial interest in another license. So a cultivator who couldn't get a license, if they had a beneficial interest in a distributor, processor, or dispensary, and the same thing for processors and distributors, they couldn't get a license if they had a beneficial interest in another licensee. For dispensary licensees, they'd be limited to one license, except that a spouse of a licensee could own and hold a license for another dispensary.
Thank you. Questions of the reviser? Representative Smith, you have a question.
No, I guess I don't. I'm reading back through it. I thought this had something to do with the 90 days.
The first page, the first little balloon that's out.
Oh, okay, Matt, let me ask you this. Is there anything in here that describes what a 90-day supply would look like, a dosage rate? Because I know that when I was pursuing one of my amendments, the question became exactly what do I mean by dosage? So the onus was put back on me to come up with a dosage. How do we describe a 90-day supply in any matter that we haven't even decided what it will look like? Can you give us an idea?
Well, Representative, go ahead.
Let's let Matt answer that.
That's to be established by rules and regulations. So the bill foresees that the supply amount to be determined by the adoption of rules and regulations.
Thank you, Matt.
Thank you. Further questions on this amendment? Seeing none. Representative, you have another amendment?
No, Mr. Chairman.
Oh, that's the only amendment you have?
Yes, Mr. Chairman, we'll put them together.
Thank you. Representative Wagner, thank you. You have your amendments?
I do. And,
have you given them to, just give them to Jeannie there, she'll come in. We're working Jeannie pretty hard today. And Representative, is this your first of four?
there's really 5, but I'm just going to present 4.
Thank you. All right. So if you want to mark this as Wagner 1,
yeah,
we can identify it later.
And if I may, Mr. Chairman,
Please.
explain it. This one is pretty simple. It's just a signage requirement in dispensaries. It's a fairly well-known effect, or very well-known effect, that marijuana has a negative effect on women who are pregnant and on people who have any sort of psychiatric and emotional disorders, as far as it's been implicated with people with psychosis and schizophrenia and such. But this would just require a sign on both the entrance and exit of dispensaries that would be a warning, much like perhaps you're used to cigarettes, but this is in the dispensary.
Matt, if you would.
Thank you, Mr. Chairman. So the first page of the amendment would require the Board of Healing Arts to adopt rules and regs to establish those signage requirements. And then the second page would require dispensaries to display and maintain a 9 by 18-inch sign that was displayed by the checkout counter and the primary door of entry and exit that included that warning about health risks.
Thank you. Questions of the preparer of the amendment? Yes, Representative Wagner. I'm sorry. Go ahead. Representative Garber.
Yes, Representative. Are there any studies that you can show us that medical marijuana does what you say it's doing in this amendment?
Yes, I can. I mean, I don't have the details here with me, but it's not just theoretical effect.
Thank you. No further questions. Representative, you may give us your second amendment.
All right, she has the second amendment. This one relates to section 34 about the admission of additional, not symptoms, but additional ailments that people can prescribe or add on for medical marijuana, and this would just do a 3-year, I'll call it a cooling off period, but it would, since this is such a new area we're going into, it would prevent any additional ailments from being added for the first 3 years.
Thank you. Matt, if you would.
Thank you, Mr. Chairman. So I'll just clarify the amendment. So it's this would prohibit for 3 years a person submitting a petition to Director of ABC for a new form or method of using medical marijuana. So it would require that 3-year delay before petitions could be submitted to the director for a new method of using medical marijuana.
Thank you. Questions of the bringer of the amendment? Seeing none. Representative Wagner, do you have a third amendment?
Yeah. This one is actually, I have it listed here as number 4. I'm kind of passing over number 3 for a couple reasons.
Okay.
But number 4 just goes after in a couple, section 20 and three other sections, 28, and I believe it's 31, there is a basically racial set-aside. Just thinking that's an ill-conceived measure. I know this overlaps something I believe that Representative Garber had yesterday, but this is just a standalone amendment to strike that wording.
Thank you. Matt?
Thank you, Mr. Chairman. So yes, there's a set-aside provision for cultivator, laboratory, processor, distributor, and dispensary licenses of 15% of those licenses for certain groups, and the amendment would strike that set-aside of those licenses.
Thank you. Questions of the bringer of the amendment from committee? Representative Reese.
Representative, why do you want that stricken?
Because in Kansas law, I mean, we have a Kansas Act Against Discrimination that it's supposed to be an equal opportunity playing field, and I think racial set-asides run counter to that, and I think the regulatory bodies would not have a problem as far as just ensuring equal access to all comers.
Thank you. Representative Clayton.
Thank you, Mr. Chair. My question is just more of to keep my files straight. I saw that on the copy it said Wagner number 4, but I have it, at least in my files, as Wagner number 3. I just want to make sure I'm on the same page as I'm trying to keep all this.
I think the representative indicated he may do them in different order.
Okay. Thank you. Sorry, I didn't catch that.
That's right, but we'll refer to it as Wagner 4. Representative, do you have another amendment?
Yes, and this is the fifth and final amendment. Oh, I'm sorry.
Hold it. All right. Go ahead. Question on number 4.
Yes, thank you, Mr. Chairman. Representative, what is the percentage of these minorities that have been incarcerated for said offenses with said substance, and how does that compare to the percentage of this set aside?
That's a good statistical question. I would imagine it's somewhat statistically higher, just knowing general crime rates, but I don't actually know the answer, the percentage.
Thank you, Representative. I would imagine that that particular set aside is there to do some type of remedy to those individuals that from those particular communities who have not had the opportunity to start their lives, get jobs, or have destruction to their families. I would question why are we taking that out exactly. Thank you.
Thank you. Representative, just to make sure, Representative Wagner.
Yeah.
I've been handed a new amendment. It says Wagner 5.
Right. The fifth and final. In the this strikes basically section 48 and section, I think it's 60. There's two sections in there that 64, I mean, that were a little surprising in that they basically turn users of medical marijuana into a protected class. In the Kansas Act Against Discrimination, protected classes are typically very, serious and sizable as far as race, religion, such as that. This would be, I checked with legislative research as to, is there any other situation where a protected class is based on what you eat, consume, or such, and they answered in the negative, which is what my understanding would be. And so it just seems that we're going down a bunny trail that I think would have long-term negative consequences.
Thank you.
It's ill-advised, I guess.
Matt, if you would.
Thank you, Mr. Chairman. So the amendment would strike new section 48, which would be a supplemental section to the Kansas Act Against Discrimination pertaining to an individual's use of medical marijuana, and would strike 64 from the bill, which just amended an existing provision of the Kansas Act Against Discrimination pertaining to a registered patient or caregiver's use of medical marijuana.
Questions of the reviser concerning what has been reflected, Wagner number 5. No questions of the reviser. Thank you. Representative, you have other amendments?
No, that's it.
Thank you. Representative Woodard, you now prepared?
Thank you, Mr. Chair. I have one of them, and it's pretty simple.
Yeah, I'll have Jeannie come up and get copies so she can hand it out. And we'll mark this Woodard 1.
Yes, please. This amendment would remove the prohibition of smoking, vaping, and combusting of medical marijuana.
Okay. Matt, if you would. This would be Woodard's, Representative Woodard's 1.
Thank you, Mr. Chairman. The amendment would make 2 changes. On page 3 of the bill would strike the definition of vaporization. And then in new section 33 would remove the prohibition of smoking, the combustion, or vaporization of medical marijuana.
Thank you. Representative, you have further explanation, or are there questions of the bringer of the amendment? Yes, Representative Jacobs.
Thank you, Mr. Chair. Representative Woodard, is this kind of goes in the same lines of Representative Garber, what he introduced yesterday?
Thank you, Representative. I believe it's similar, but I would have to review, and maybe that's a question for Matt, but this would remove the prohibition from not just vaporization, but also smoking and combusting of medical marijuana. I'm not sure that the Garber Amendment did that.
Okay, thank you, sir.
Thank you. Further questions of the bringer of the amendment? Seeing none, thank you. You have another amendment, Representative Woodard?
I do, and it's 27 pages long, but I promise it could probably be 1 page, and I can explain it and then deliver it as soon as it gets here.
Okay. Let me see who's got amendments that are here already. Representative Carpenter, you have amendments?
Yes, Mr. Chair.
Have you got them identified as Carpenter's 1, 2?
I do not have that written on there, but I'm sure the committee
Well,
members.
just pick out your first one, and then I'll advise the committee to mark that one as 1.
I've already got mine.
Okay. Jeannie, if you would hand those out, the first group.
Yeah, we had one yesterday, so this would be
So
Carpenter 2.
This would be Carpenter's 2. This is just one amendment.
It is one amendment, but it has multiple items in it like I did yesterday.
Okay.
So if you'd like, Mr. Chairman, I can explain.
Please do. And go by page.
I can do that. Yes, yes, Mr. Chairman. So committee, what I'm doing here is you'll see that I'm changing on the first page, page 6, the criminal offense for if you were to receive a gift, a gratuity, what have you, or obtain employment. If any member of the ABC or anybody like that were to issue a license based on bribery or anything like that. So that specifically is what that is doing. We can debate what level of penalty that needs to be. I'm not 100% stuck on that level of penalty, so I'm more than happy to debate that. Page 2, I talked to the KDH&E legislative liaison and sent them an email, have not gotten an email back, but when I talked to them last week, they indicated that they will be setting up an electronic system for the identification cards. So they had already had process. They were already thinking and considering about doing that. And so basically, this amendment just makes it a very broad statement that we want to be able to have instant verification of these medical marijuana patient cards. So if they go into a dispensary, the dispensary would scan the card, it would bounce it against the KDH&E database, and then it would basically come back as red, you can't sell to them, green, you can sell to them because they are a person that is eligible and is in the database. So it's just basically setting that in statute instead of leaving that 100% to rules and regulations. The next amendment on page 11 is basically, there's been some conversation about having that patient-physician relationship. And some believe that it is not Some believe that we should remove that completely. However, I am not in agreement with that, and so I limited it from 12 months to 6 months, but I also added some caveats in here to where you can also, patients who are currently receiving medical marijuana from their physician, and let's say their physician retires, then that physician would be able to say, well, go to this other doctor, I'm going to recommend you to this other doctor. Then you can go around that 6-month waiting period if you have a referral, basically, from your current physician. So that would allow you to then go to your other doctor. The other physician would examine you, and then from there, you'd be able to continue to be prescribed or recommended medical marijuana. And then also, if you're a veteran, a lot of veterans use the VA, and they don't have physicians that have the ability to use medical marijuana currently. And so what I did was, for the initial patient-physician relationship for veterans, I waived that 6-month period. However, if they are to transfer physicians at any point, they will have to follow the procedures laid out from physician to physician recommendations. The next amendment is setting up a fee structure based on per plant. It is very similar to the Garber amendment yesterday. The fees are just a little bit more, though, and in total, if you were to add all the fees up, it would be about $100,000 if you were to have the maximum amount of plants. The Garber amendment did not have a maximum amount of plants, if I recall correctly, so in my amendment, it sets it to where it's 1,750 plants, and then you can do 500 plants annually upon your renewal with the permission of the director during that renewal. The next amendment is on page 22. And this is giving counties the option to pass a resolution to not permit dispensaries within their counties. So it gives local control to counties on whether or not they wish to have dispensaries within their counties. There are actually currently still, I believe, 4 dry counties in the state of Kansas that do not sell alcohol. So I figured that, if we still have counties that don't sell alcohol, there might still be some that don't want to have marijuana within their counties. Next amendment on page 25. This amendment comes because right now in the bill, before all these amendments have been introduced, it left it up to rules and regulations to determine the amount of licenses based on population of the size of Kansas. And so what I'm doing here is basically coming in and saying, here's how many licenses will be offered under each of these entities or licenses that will be allowed. And we heard an amendment yesterday that would remove the cap completely. So we have 3 different flavors. We have the remove the cap completely, we have the leave it to rules and regs, and then we have my amendment now, which would allow us to debate, figure out what numbers we want to have. The numbers of cultivator and dispensary licenses are based very similarly off of Arkansas, and that is because Arkansas has 3.2 million people. As of 2019, we had 2.9 million, and I increased those licenses just a little bit because of how much land and territory Kansas has versus Arkansas. And then on page 29, this amendment I think is kind of a fun one. It's renaming alcoholic beverage control, and it's renaming it to alcohol and marijuana control. I did talk to the director, and basically she said she had no opinion and would leave it to the will of the committee because other states have renamed their enforcement agency after they passed marijuana regulations as well. And then I believe the last and final item is the item that was brought up yesterday, that if somebody is traveling through the state of Kansas, that they have the ability to travel basically through the state of Kansas without suffering consequences, if I believe that last part is written correctly. Thank you, Mr. Chair. I'll stand for questions at the appropriate time.
Thank you. Matt, if you'll give us, I thought the bringer of the amendment did a good job explaining, but if you have any points, go right ahead.
I'm not sure that I would clarify anything the representative said. Just that, yeah, the last piece that he discussed was, it's an exception to that possession prohibition, and pursuant to what the committee discussed yesterday in terms of that affirmative defense, it would allow a resident of a state or a resident of another state that is temporarily in Kansas and whose acquisition and possession of medical marijuana was in conformity with the laws of their state of residency, they would not be violating that possession of marijuana requirement as they pass through Kansas.
I got a question, Matt. Their definition of temporary? I mean, is it 180 days, 90 days, 30 days?
There is not. That could be something that the committee explores to clarify. This was language just kind of put together with the idea of addressing the issue of somebody who is passing through the state. If there was the intent to apply it to an individual who was maybe staying at a friend's house for a month or something in Kansas, it might need additional clarification to mean what the intent is for temporary.
Thank you. Representative.
Thank you, Mr. Chairman, for calling me on the second time. I just really quickly wanted to say, God bless the reviser and helping us with all these amendments.
I agree with that. One more question for Matt. Matt, I had a bill a couple of years ago where we, I think that, we don't control folks in other states. And we had an amendment attached to one of the bills, I think it was in Judiciary, where it was at, where it just stated that if you were in transport, if, for example, if you were going from Missouri, which is a state that has it, to Colorado, go skiing, that if you got stopped by a Kansas officer and you had green vegetable matter, commonly called marijuana, in your car, then the officer, even under our existing law with medical marijuana, if we don't have the non-smokable, they could arrest you, and that was the testimony of the law enforcement. And I think we allowed them to issue a summons and then grant them an affirmative defense. They would just contact the prosecutor's office and show that they had a card or whatever that state gave that individual to possess it. And then that case would be dismissed. Representative Heiberger, do you recall that?
It sounds to me like the CBD oil bill that we passed.
Well, no, it was maybe attached to the CBD oil bill, but it was a specific amendment that I thought that because of, if you get it legally in one state and you're just in transit through Kansas, if the police stopped you and found loose marijuana, they would not be able to arrest you in front of your kids and your ski equipment. They would instead give you a summons, and then you could exercise your affirmative defense with the prosecutor. This is very similar to that. The only thing I remember having questions when we brought that amendment, what would be temporary? And I think the consensus of the committee at that time was, probably 60 days or no more. If you come here and do a vacation, if you bring a month's sample or a month's supply of marijuana, then you could always exercise. But if you're coming here to spend 6 months, it's the same as a driver's license. You got to get them, you can't do it. But that was just a question that I had. Based upon the amendment, questions of the bringer of the amendment. Yes, Representative Wagner.
Yes, Representative Carpenter, I really appreciate the work you're doing here. My question on the county commissioners and the county opt-in, opt-out, that only applies to dispensaries? It would not also apply to cultivation or the other aspects of the marijuana industry?
According to the amendment, it only applied to dispensaries.
Was there sort of a rationale, just simply you didn't think the others were as critical?
Well, I believe that, if you could, in my opinion, grow it, most people probably wouldn't even know you're growing it, and then you could have it shipped off to the processor and then carried on to the dispensary at that point. And it's not like people are going to be going up and, purchasing the crop right out of the field or anything like that, or hopefully they're not. And so that is why I think dispensaries, because people just might not want the specific point of sale of the dispensary within their communities.
Thank you. Yes, Representative Howe.
Thank you, Mr. Chairman, for the carrier of this amendment. So say a patient is diagnosed with a terminal cancer or something like that, and they do not have the opportunity to maintain a relationship with their doctor, like an oncologist or something like that. How would your amendment affect someone in a situation like that?
So how would it affect them in that situation? Under the way it's currently written, they would have to go to, under the way the current law is written in front of us, without my amendment, they would have to wait 12 months before they would be able to receive, my understanding anyway, is that they would have to wait 12 months before they'd be able to start receiving a new recommendation for that medical marijuana. However, under my amendment, it would waive that waiting period, because if you were the oncologist and you're saying, hey, I'm retiring, I just can't go on anymore, but I know another oncologist who is a great guy, the other oncologist would then receive the medical record, talk to the other physician, and then do a analysis of that patient, and then if it's their opinion that they would benefit from medical marijuana as well, it would waive the 6 month, I'm changing it to 6 months, 6 month waiting period for that individual to where they could then still continue to receive medical marijuana.
Thank you. I'm going to ask a question of Representative Epley on his amendment, and see if those sync, so to speak. Your position on the doctor issue about relationships. Your language is similar to this, but not, if you'd restate your.
Mr. Chairman, again, we were at the end of session yesterday. I didn't really have a chance to explain any of my amendments, and if afforded that opportunity, I will, and it is different than representative from Sedgwick.
Then I will come back to you after we look at the other amendments.
Sure. Thank you, Mr. Chairman.
Thank you. Representative Smith, you have a question of the bringer of the amendment?
Yes, thank you. So this last piece that says not a resident of the state is in the state temporarily and whose acquisition, et cetera, et cetera. Basically, if they tell me, and try to put yourself in my position, I stop this vehicle and he's got a gym bag in the back full of different edibles and 4 bags of vegetation, et cetera. And he says, hey, I'm from Colorado and I got a medical card in Oregon and come at me, bro. How do I deal with that on the side of the road, trying to determine the laws of 2 different states plus Kansas? And are we talking about immunity? Are we talking about affirmative defense? What are we talking about?
Thank you for the question. My understanding is that we're talking about affirmative defense. And if they had 4 kilos in their trunk, you know, that's probably more than a 90-day supply. So I would imagine that you'd be able to confiscate that material at that point in time, and then they would be able to go argue in front of the judge. I'm gonna refer this to the revisor or to somebody who is a judge or was a judge on how the legal system would work in that regard.
Chairman, if I may.
Please.
The problem you run into is some of this stuff is going to rot, and then we're going to be responsible for it, should they be. So if I start confiscating marijuana that could or could not be legal in another state, we could ultimately be responsible for repaying the cost of it. It opens up a Pandora's box, and so that's my ask here is, have we considered that? Thank you.
Thank you.
Thank you, Mr. Chair. This is for the carrier of the amendment on page 25. When your balloon here that says that shall not exceed a total of 10 cultivators, 5 laboratory licenses, and so on, is that per the state, per population, or how will that look like?
So I base that off of, so the 2 licenses that the 2 numbers that I based the cultivator and the dispensary licenses off of were Arkansas. And so Arkansas has roughly, we don't know their census numbers yet, we don't know ours yet, but according to the Googles, Arkansas has 3.2 million people, Kansas had 2.9 million people as of 2019. And so Arkansas, they had 8 cultivator licenses and 40 dispensary licenses. And so I increased the cultivator licenses by 2, and I increased the dispensary licenses by 20 because we have more land mass than Arkansas does. And so I want to make sure that those folks out in western Kansas, you know, have the ability to basically not have to drive all the way into Sedgwick County, but would also have the ability to, hopefully drive to somewhere like Dodge City if that county doesn't prohibit it.
Thank you. If I may, who would determine the locations of these dispensaries and so on? Is it just first come, first served type of thing?
I did ask for rules and regs to specify that. However, I'm not seeing that, but that might be what's in section 20 and 22. If I could have the revisor clarify.
Thank you. Matt?
Thank you, Mr. Chairman. So currently in the bill in section 31, there's the requirement that the director, when establishing the number of retail dispensary licenses, considers the population of the state, the number of patients seeking to use medical marijuana, and the geographic distribution of retail dispensaries in an effort to ensure patient access to medical marijuana. So those requirements would still apply. The Carpenter Amendment would just add a specific cap on the total number of licenses. So the director would still have to establish those licenses pursuant to those requirements.
Is that helpful?
Yes, sir. Thank you.
Thank you. Further questions of the bringer of the amendment, Representative Garber?
Thank you, Mr. Chairman. Representative, how long has Arkansas had medical marijuana?
If you know.
I can find out.
Well, it's not a big deal. I guess my main question is, we're limiting the license in the dispensaries and all of this. I think at some point it's going to go to court, and the court is going to determine that that's unconstitutional to give a license or a number of dispensaries to one person and not another. And the other question I have is, I guess the observation I have is, we're telling an industry they can only do this, this, and this. We're taking away their liberty, and we're telling the county commissioners that they can take away their liberty also. So at one point, we're restricting it at the state level, but yet we're telling the county level they can go ahead and do what they want. I'm kind of confused with that. Thank you.
Thank you. Short, please, and I have a few more amendments.
All right, thank you, Mr. Chairman. It's the question in front of us today, in my opinion, is medical marijuana, not recreational marijuana. So if we want to make it to where licenses are super affordable and unlimited, then in my opinion, we're going towards recreational marijuana. And so that is the reason why I'm putting the caps in here, because there's only so many people who will meet the list that we have in our current bill. There's only so many people who have glaucoma, cancer, so on and so forth within the Kansas population. And so if you were to open up 5,000 dispensaries, well, in my opinion, it's unfounded. We don't need it. So I just wanted to point that out, Mr. Chairman. Thank you.
Thank you. Representative Garber, you have...
I agree with what he said so far. However, I think that the amount of money that we put in place to start a business and put in a dispensary is going to prohibit many people from being able to do that, just by the amount that we set in those fees.
Thank you. And the debate will be when the amendment's offered and when the chair is taking that. Other amendments, Representative Woodard. Jeannie, if you can carry that load.
Jeannie, it looks like this is still being amended. So to save us all from needing a medicinal marijuana prescription, I will not offer this amendment. It would have been a gut and go that would have gutted the contents of this bill and inserted House Bill 2430, which is a full legalization bill. Thank you, Mr. Chair. I won't be offering the amendment.
All right, thank you. But could it be offered when we're actually working the bill?
We'll see.
The mask? I can't hear you.
We'll see. Probably not. We might have to save it for the floor, or I'll be talking to you about the future of a different bill. Thank you, Mr. Chair.
Thank you. Further amendments? We've arrived at the end of the amendments. I promised, we do have another amendment? No, I indicated earlier Representative Epley introduced his three amendments, at the close of business yesterday. He did not get an opportunity to fully explain them. And Representative, would you like to do that now?
Thank you, Mr. Chair. You're very generous, and I will say that I guess I'm going to pile on amendment by the amendment filibuster here, but I'll try to be very, very brief. I handed out basically 3 things yesterday. I don't know if you all brought them or not. I'm going to do the first 2 because they're very easy. The third one's a little more complicated, and I have an explainer that I actually did for you, and I'll hand it out when we get to it. The first one is about the Board of Healing Arts. It references page 11, lines 27, and it's 2 paragraphs. I don't know if you brought it or not, but it was yesterday in that slew of amendments that were brought. Again, I had 3. What this does is it allows rules and regulations to be adopted by the Board of Healing Arts for those individuals that want to have marijuana, I guess you would say, capacity to recommend. And there is a fee involved with that because these will be vetted by the Board of Healing Arts. They'll have to be physicians that have certain, qualifications as vetted by the Board of Healing Arts, and they're going to charge a fee not to exceed $175 for that to happen. That's my first amendment. Second amendment was brought to me by a lobbyist that I think is very important. It involves from labor practices for business so that their motives for drug testing and such can remain in place, and they continue to do drug testing and use that as a basis for employment or not being employed. That is starts on lines 29 on new section 45, line 32, and there are 4 pages to this amendment that I passed out yesterday, and they just reference, again, workman's comp abilities to do drug testing as it exists in current statute for that to be maintained. This was brought to me by the State Chamber, and I think it's really valid, and I think we should pass it out with the bill.
I'm going to stop you there. The first amendment with the Board of Healing Arts, I'm going to mark as Epley's 1.
Yes, sir.
I'm going to mark that. I didn't mark them yesterday.
Yes, sir.
So
that's
the
Epley 1.
One from about the employment will be Epley 2.
Correct.
All right.
Then if I could just have some assistance to pass out this form right here, please, to everybody. So the third amendment, Mr. Chair, and again, I will do my best to be brief, is really what I will call quality assurance amendment. It boils down to 3 areas. It involves physicians that prescribe, laboratories that assess and examine, and pharmacists' involvement with dispensaries. The first section of this is 15 pages, and you can go through it with me. It's the big one from me yesterday. And the first part of it starts with a definition of designee, which relates to prescriptive ability in a little bit. It's just a definition and its restatement, and Matt may want to talk about that, but this is not to allow designees to prescribe marijuana. It's just to allow them to work in an office and to help facilitate transferring information to K-Trax and to monitor what's going on. On the next page, page 8, line 29, references 30 days. I decided that we should handle marijuana products just like we do opioids and allow 30-day supply and be done with it. Anything else that's definitionally, I think, just gets us in a rabbit hole. And so I changed it where it says a 90-day supply. I made it all consistent with the 30-day supply in statute. Again, that's on page 8, line 29. Next item of this amendment is pages 11 and 12, lines 33 through 37. There was a deletion of some language on those 2 pages. If you're following along by any chance, on pages 11 and 12, deleting basically about eight lines that describe the physician's relationship. And what this tries to codify is basically a normal physician-patient relationship. It's established by an initial office visit. You have to review old records. You have to understand the indication, the appropriateness of the tetrahydrocannabinol recommendation, and then you must do a physical exam. That's sort of standard operating procedure. There is no, and I will emphasize this, no 12-month relationship that has to be established in place first. That doesn't exist in any other part of medicine. I don't know why it would exist here. If you see a patient, you examine them, you review the old records, you determine that they are appropriate for a THC recommendation, you're good to go. That can remain in force for up to 6 months. If you, for whatever reason, the patient wants to change physicians, he can after 6 months, but this locks him in for 6 months because this will deter, I think, patient shopping, you know, from doctor to doctor. I think that's really important, and that's at the very bottom of that amendment, where it says that has maintained a physician-patient relationship with a new recommending physician for at least 6 months with either inpatient visits or via telephonic or electronic means. This does not specify how those visits occur. It can be either over the phone, or it can be by Zoom, it can be by telehealth, it can be in person. It can be however the doctor and the patient want to determine that. The physician must have, his designee can transmit records, but that's all, to KSA 65-1683, which involves K-Tracks, and can do research on K-Tracks because that's necessary. And I think that's pretty much it on, that's the big part of that amendment as it relates to physician definition and physician relationship. And then the next several amendments, page 15, 16, there's three references. This is all about lab and lab testing, quality assurance, integration with ABC. You can read those, and again, Matt may want to expand on this, but this allows for a lab accreditation, inspections, and compliance via ABC. And it does allow down on page 24, line 28, the ABC director to have the ability to require sample submission at zero notice if they want to from any point of manufacture of the product. And the final part to this touches on other amendments that we've heard today, and this is, again, my own creation based on law from many other states. I think we get ourselves in a bad place if we fly against the DEA schedule, the Scheduled Drug Act, and it gets us in a bad legal place if we try to make dispensaries pharmacists. And so my language on page 22, page 24, and page 26, referencing also the attachment, basically describes a pharmacist acting as a consultant with each dispensary. I think this is necessary for the optics of quality assurance and for safety of Kansans. This does not make dispensaries pharmacists. I thought that would be inappropriate and frankly illegal. I have visited with both the pharmacy board and also the Pharmacists Association, and they're all in agreement with this language. I just want everyone to know that. The pharmacist will oversight and audit every THC recommendation and the appropriate amount of medication prescribed. There is software that's available now, apparently, for drug tracking through K-Tracks. It will require a small fiscal note, but K-Tracks can be expanded to monitor and follow THC prescriptions, so we'll know who's getting what, how much, and when. I think, again, this is important. We have the capacity to do this. This is just like we do opioids. You know, that's my world. And, I mean, every day I go home to Atchison, and trust me, I have 2 or 3 folks that I have to do. I do Arcopia / research on K-Tracks and prescribe opioids for people that need palliative end-of-life care. That's about it. As far as the list, I think the list is a good place to start that's in the bill right now. I would not recommend expanding that list or locking it in. My gosh, let the physicians have some input on this, and if they want to modify the list with the trailer bill, maybe in a year or 2 we can do that. But I think what I've tried to codify is what I think is a fairly normal situation for doctors to try to function within 2184, and with that I'll try to answer questions.
Thank you.
Sorry for the long explanation.
No, that's quite all right. You didn't get an opportunity yesterday, and I wanted to give you that opportunity today. Questions of the bringer of this, either Epley's 1, 2, or 3? Matt, do you want to go through an overview?
Thank you, Mr.
Do
Chairman.
you want to? Go ahead.
Happy to. The only thing I would add, all the policy pieces I think Representative Epley accurately laid out. I would just expand on the attachments as part of his amendment. New section 22 is a provision dealing with requiring the director of ABC to contract with a private laboratory for the purpose of conducting compliance and quality assurance testing. Kind of like it's going to have an official laboratory testing that works with the director so that they can oversee the quality assurance of the medical marijuana laboratories in the state. Section 23 has a number of specific requirements for how other licensed laboratories in the states will conduct testing. Section 24 is directing the director of ABC to propose rules and regs and for the Secretary of Revenue to approve rules and regs pertaining to acceptable testing and research practices in the state. And then attachment 2 would add a new section 42 that pertain to pharmacists that would operate as pharmacist consultants for a dispensary in terms of requiring them to register with the Board of Pharmacy and certain requirements and restrictions on how those pharmacists operate in that dispensary as a pharmacy consultant.
Thank you. Questions for the reviser? Yes, please go right ahead.
I forgot to clarify, and Matt didn't mention either. So I want to be sure. There's concerns a bit that this pharmacist consultant might hold a dispensary hostage over their fee they would charge. And so I heard that, and I listened to that, and heard all sorts of ideas thrown around. Finally decided the best way is to put a ceiling on it of 2% of gross receipts. That's actually codified in that attachment. I didn't know how else to handle it so that there is a limit. And, you know, honestly, as I looked at this, a pharmacist, and they agreed, they could act as consultants in 2 or 3 dispensaries if they wished, and that would be a reasonable salary at that point for a pharmacist in this day and age. So that was just my method. I think that could be changed. There may be a better way. I thought an arbitrary amount was bad, so I thought it should be incentivized based on gross receipts, and that's all. Thank you.
Then I have a question. What if a pharmacist wants to be a dispenser? Could he be his own consultant?
I would look to Matt. I don't know if that's addressed in what we drafted or not. That's a good question.
Okay. I mean, if he's quality assurance, I'm sure his product, if he had a dispensary, would be superior to most. It's just an area that it would appear to me that if he has a dispensary, he would have to hire a separate pharmacist to come in. And that would be normal. That's what I thought. And good. Questions for the carrier of the amendment? Seeing none. Representative Garber? Yes, go ahead.
Thank you, Mr. Chairman. According to what you said, K-Trax was, its purpose is to identify and reduce drug abuse, specifically with opioids, methamphetamines, and prescription drugs, basically, correct?
Correct, yes. Uh-huh.
Okay. So I'm trying to figure out what abuses we're trying to prevent. Is there any evidence that exists that cannabis is physically addictive? Any studies?
So that's an excellent question. I'm sorry, Representative, I thought it was somewhat assumed.
I don't know that there is. I don't know. I'm sure a lot of people in this body are more aware of this than I am, but there are safeguards in the cannabis industry that are, in my opinion, better than K-Trax. Every seed that is sold eventually has an RFID on it, just like your credit card. And that is tracked all the way through to the point of sale. It's called seed to sale. And somebody has probably seen that. Somebody has probably seen how that works. I haven't yet, but so it's tracked. It's tracked all the way through the system. So at any point in time, you can go and look at that RFID number, put it in the reader or whatever, however they read them, and you can tell exactly what has happened to that specific seed or plant at any given time through the system. Also, when a person goes in to buy in a dispensary, they have to show an ID card to say that they're 21, and they have a state-issued cannabis card. And when they produce that state-issued cannabis card and want to buy that product, the cashier, if you want to call them that, puts that in there in their cash register, and the cash register will tell them whether or not they are over their 90-day supply already. So in my opinion, that's much better than K-Trax.
Thank you. Committee members, any other comments about any of the amendments? Seeing none, tomorrow we are working some bills and they're out on the agenda. Bills that we've previously heard. I'm trying to give you enough time to go through all of these amendments and arrive at a position prior to being offered the amendments and going through each and every amendment. For those that are new, it's not unusual for a motion to be made to divide amendments. It's solely within the discretion of the chair whether they divide it and how it's divided. But I would anticipate when we're doing this that that may be a request. I think all of you have a lot of reading to do. I know when Representative Carpenter called me last night, we were both doing the same. We were reading amendments, and I had a question about one. But with that, let's take we're going to get out of here a little early today, about 10 minutes early. Anything else for the good of the committee? Oh, yes. What would we do without Connie? I would entertain a motion to approve the minutes of 2/11/21. Representative Reese has made the motion. The second is by the Vice Chair. Discussion, seeing none. All in favor say aye. Those opposed, no. Opinion of the chair, the ayes have it. The ayes do have it. The minutes are approved. We are adjourned until tomorrow.